Now in this case, we're seeing the law is being challenged as unconstitutional, and that's for three separate reasons. The first is that the law is a violation of the Equal Protection Clause of the Constitution. This challenge is being brought by a white family that sought to adopt a Native child, and they're arguing that the placement preferences that the law imposes, which put first other members of the child's family, then other members of the child's tribe, and then other Indians, then following anyone else, so that by being anyone else, they are being racially discriminated against because this preference for either other Indian families or tribal members is a violation of their right to equal protection. So it's racial discrimination against them. However, in tension with this is longstanding precedent from the United States Supreme Court that says that Indian membership categories and Indian status that's intertwined with that, that's not actually a racial classification per se. It can be thought of as a political classification. That's not to say that Indians are not also a race, but that when Congress is doing various things that have to do with Indian peoples and tribal members, they can be thought of as regulating them as a political group, not as a racial classification. This matters, of course, because it changes whether or not it triggers strict scrutiny under our constitutional doctrine, which would make it harder for Congress to act whenever it's regulating Indian peoples.